Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm reviewing a book which has just come to us. It's actually going to be published in 2016, although I'm recording this in December 2015, and we've just written a review of an urgent advance copy. This book is called The Status of Children Arising from Inter-Country Surrogacy Arrangements. It's been written by Michael Wells Greco. It's part of the titles in the 11 International Publishing series covering certainly family law in this particular area of law. Now, my wife Elizabeth and I have written a review of this book, and we've given the review title for our review the following: The Legal Implications of Inter-Country Surrogacy and Some Recommendations. Now, the reason I mention that is because we are dealing today very much with family law problems on a much more international scale than we've had before. So I do welcome 11 International Publishing producing this book. This is the book here, nice white cover. Then there's the actual spine of it there. And then at the back you've got a little bit of detail about the book and some information about Michael, the author. The book runs to something approaching 550 pages. There is no index at the back as such. What you've got is you've got a series of appendices actually at the back, running through very detailed appendices, and in fact they start around about, just about page 500, so there are about 50 pages of appendices. Deal specifically with human rights of particular significance to children, and this is the Universal Declaration of Human Rights as much as anything else. Something which quite often is ignored because there's such a hoo-ha about the Human Rights Act and the European Convention. They forget about the Universal Declaration, which started it off. There is the front page. By the way, it's more important as well, because that was the reasons why it was created in the first place. Table of contents, you notice there's paragraph numbering, which is quite useful to have, and then that runs all the way through. There are actually 6 main chapters. Then you've got a series of appendices at the back dealing specifically with human rights. Then you've got the abbreviations side, then a glossary of key terms, very useful I think certainly within the international context. International surrogacy arrangements, for instance, with definitions, which I think will be of help to anybody involved in this area. Then an introduction. I'll just read it. It says, this book is about the status of the child and the determination of legal parentage and birthright nationality of a child born in a case of inter-country surrogacy. And we're going to get more of this in future, so I think this book is very valuable. There is the paragraph numbering and there are the footnotes there, and that runs all the way through. And we're looking, and what he does look at throughout is specific countries. So you've got a wide range of different countries. The only thing I would say about this book is that you will need to use the index at the front specifically to try and find what you're looking at for, because there is no index at the back. So it's just the contents section that will help you depending on what you're specifically looking for. But it's well written and it's a good book, and this is what we say about it. When it comes to human reproduction, science can often succeed in instances where Mother Nature has failed, hence the proliferation of assisted reproduction technology, or ART, and or medically assisted reproduction, MAR, each defined, and look at the detailed glossary that's in the book, in this interesting and extensive piece of research on the complex legal ramifications of surrogacy, inter-country surrogacy in particular. As I've said, I think this is a subject that's going to become more important as the century unfolds. The author is Michael Wells Greco. He's an academic at Maastricht University. He's also a partner of an international law firm specialising in cross-border family law as well as private client matters, and is amply well qualified to carry out this in-depth examination of a phenomenon that is becoming increasingly more frequent. The book, as I say, has been published by 11 International Publishing, who are based in The Hague, and the volume has almost 600 pages which discuss the complicated topic in detail. And complicated it is, as the traditional concept of the family, that's the married heterosexual parents and children conceived by natural means, has broadened considerably in the last couple of decades. As the author reminds us, a child born as a result of a surrogacy arrangement can have up to 6 potential parents, 2 gamete providers, the gestational birth mother, that's what we know as a birth mother, and her husband or partner if she has one, and the 2 intending parents, wherein these are different people. Now, anybody involved in family law, certainly in public children matters, as I have been, will be aware of how complex it can become quite quickly, and how many parties can actually become joined into the proceedings. So you see the difficulties immediately. There are, of course, further complications of a legal nature, which obviously arise when the individuals involved reside in different countries, in this case mainly European countries, for the purposes of this research. And that's why I think the book is important, because of the way our relationship in the United Kingdom, for instance, is going with the rest of Europe, and the fact that people are moving around much more than they ever did. The legal focus then, quite rightly, is on the rights and welfare of the child born as a result of an inter-country surrogacy arrangement, in which case obvious questions will arise. For example, what is his or her nationality? What are the laws on parenthood? And who are the parents directly responsible for the child's upbringing? And forget any other issues such as cultural and other points. These are very basic, standard questions that have to be answered. And the fundamental rights of the child to an identity and to protection are of paramount importance here, and are the prime consideration of this research. The author's concern on the matter of statelessness becomes evident with the warning that, quote, as long as a child is without a nationality, that child's basic human rights remain at a risk of violation. So, undertaking a comparative review of 8 legal systems, the author examines the legal aspects of parenthood and nationality resulting from inter-country surrogacy, particularly, as I say, with reference to European and international human rights law. That includes, as I've said, the Universal Declaration on Human Rights, as well as the European Convention. And it offers various soft and hard law recommendations aimed at protecting the interests of the children concerned. I think I'd like to conclude by actually saying here that for European lawyers advising on cross-border family law matters, this book is a valuable find, incorporating as it does a wealth of references in the footnotes and the 30-page bibliography in the book for further, even more specialised research into what is becoming an increasingly important topic. And I say that because I can see that this is going to be much more of an emerging subject in the future. The publication date, as I say, is cited at 2016, and I'm recording this just before then. Excuse me.